Sir, may I proceed with the argument? Thank you, sir. In the Honorable Allahabad High Court, Court of Judicata UP, dated 11 January 2025, writ number 503/2025, in the matter of under the Article 226 of the Constitution of India and in the matter of Article 14, 21 and Article 3008 Constitution of India, between Sri Lal Bihari, Mritak son of Chauthi Bihari, age 63, village Khalilabad, district Azamgarh, UP, in the behalf of petitioner versus State of UP through Chief Secretary and two others in the behalf of respondent. So I am Vikram Singh from the Council of Petitioner. Generally, the case summary is the petitioner Sri Lal Bihari, a school teacher from Azamgarh, district UP, after the death of his father, namely Chauthi, the name of the petitioner was entered in the revenue record and his immovable property vested in the name of the petitioners as he was only son of his parents. Point number second, the petitioner Lal Bihari was working as a laborer in a factory manufacturing Varanasi sari silk and later on established his own Varanasi silk sari manufacturing unit and was doing well in his business. Point number third, in the year 1976, the petitioner Lal Bihari wanted to take a business loan by mortgaging his immovable property and was told to get a caste and income certificate from the concerned authorities in village Khalilabad. When the petitioner went to the area of Lekpal, he was told that 1976 case number 298 he was declared dead and his entire immovable property was transferred in the name of his cousin brothers. My lord, please note down that point. The entire property has been transferred cousin brothers Patiram, Baburam and Valiram. Point number 4, the petitioner Lal Bihari was shocked for a second that he was declared dead and all his immovable properties were usurped by some other persons. The petitioner repeatedly represents to all concerned about his plight of being declared dead, but nothing was done by the respondents. Point number 5, the petitioner was forced to fight a long legal battle for himself to be declared alive. As a result, he was not able to concentrate on his business of Varanasi silk sari manufacturing unit and was forced to close it down since it was incurring heavy losses. So after all, the story represented by me, my client was regarding some issues tried to remedies keep under himself alive, such as registered a false case with police writing. Point number 2, applied for a widow pension between the age of his concerned the deceased person. Protest in Uttar Pradesh Assembly, Lucknow, fight election against India's two prime ministers. Even after doing all this, our client got nothing except mentoring around. So, last of all, respected sir, during the entire period when petitioner Lal Bihari was declared dead, the petitioner suffered grave mental anxiety and depression. The petitioner was socially rejected and was addressed by bhoot and ghost. The petitioner could not do any business in the interim period because he could not get any financial assistance from any bank. Life of the petitioners has been destroyed, my lord. Economic condition of the petitioner destroyed and destituted. The petitioner has fighting for 2 meals of a day. The petitioners have a wife, 1 son and 2 daughters to support. However, he has been reduced to the position of a beggar and therefore is unable to file a civil suit with requisite court fees to claim compensation. And lastly, is my request to court. The petition has been filed with the following prayer. Issue a writ order or direction in the nature of mandamus, commanding the respondent number 1 to pay compensation to the tune of Rs 25 crore to the petitioner for his business loss and mental agony. That is sir.
With the permission of the respected court, may I proceed with my arguments?
Proceed.
I am Devan Soni, appearing on behalf of the respondent. The summary of the case, according to as stated by the counsel, is that the petitioner was originally the resident of Khaliyaliyabad district, Azamgarh, and after the death of his father, namely Chauthi, the name of the petitioner was entered in the revenue records. The petitioner was working as a laborer in a Banarsi silk factory, and later on decided to set up a Banarsi silk sari manufacturing unit, and was doing well in his business. He has clearly claimed that he has set up the Banarsi silk sari unit and was doing well in business. It has been pleaded by the petitioner that the petitioner was declared dead in the year of 1976 and declared alive in 1994, which is 18 years. For the said 18 years, the petitioner remained vested of his property, and in the process of such circumstances he faces, the petitioner was socially rejected and addressed as fool, which directly hit his right to life. The petitioner has fighting for 2 meals a day. It has been pleaded by the petitioner in his petition, and has been reduced to the position of beggar, and therefore is unable to file a suit with the requisite claim compulsion. But sir, the respondent, the petitioner did not suffer any loss due to the cause of the state government, but he has suffered such consequences because the cousins of the petitioner has filed a fake case in his name to declare him dead, and in revenue code for cancellation of entry made. The petitioner neither initiated criminal proceeding against them and nor filed any suit before the revenue code for cancellation of such entry made. I proceed with the point business loss claim. There is no evidence that the petitioner ever running a business of Banarsi silk sari manufacturing unit which had incurred losses, or he had to fight long battle to declare himself alive. The name mutated in the revenue record in 1994. He approached court completely after 11 years of such correction and had been carried out. Only the wrong entry in revenue record causally because of the relatives of the petitioner did not entitle the petitioner to claim the compensation of 25 crores from the state government. Such a story was of setting up of Banarsi silk sari manufacturing unit by the petitioner is completely false. The petitioner did not suffer any hardship and continued his life and exercised his rights in the village Amilo since 1972. The petitioner had purchased the land from Ashraf Ahmad, Jaya Alam, Shabbir Alam in 1988 of the area 0.182 hectare, which is before he had get the right to his death certificate was rejected, and he has purchased land on his own name. His son Vijay, son of Lal Bihari, is running a gas agency of Indian Oil Corporation also, and so it cannot be said that he had been suffering for money and his life was devastated and is in the position he came in the position of the beggar. The petitioner had sufficient land in the village Amilo and had not set up any Banarsi silk sari manufacturing unit. There is no registration thereof in any of the relevant department. Now come to the point on the no compensation is decided by the NHRC, National Human Rights Commission decision. In compliance of the order 7/1/2000 passed by this court in writ petition number 29/8/06 of 1999, Jeevit Matrix Son versus State of UP and others. The matter was referred to the National Human Rights Commission, which after hearing all concerned directed the state government to take appropriate decision in the matter and did not direct the compensation to the petitioner. In compliance with the order of the National Human Rights Commission, the state government in his order number 14418/2007, 5834/11/2002, 807, dated 22/1/2007, was issued by the state government, directing all the magistrate and related officials, commissioner of divisions, to take appropriate action against the erring officials who is causing such misrepresentation and declaring the living persons dead. And such a proceeding has been made and brought to their notice expeditiously. Disciplinary proceedings were also initiated against 97 revenue officials, and criminal proceedings were launched against 81 officials. Justice had been done to 335 victims, and their lands were restored to them. The NHRC complimented the state government for its good work and found that no further actions were required and closed the case. In all the proceedings before the writ petition 29806 of 1999 and before the NHRC, the matter was conducted by the amicus curiae, which is the friend of the court, and expenses were paid by the state government, and no financial loss was caused to the petitioner during the course of such proceedings in the above case. No action against the concerned Lekpal. The Lekpal who has mistreated or declared the petitioner dead was also faced consequences and faces criminal proceeding against him. The Lekpal concerned in this case of the petitioner had also been punished by the competent authority on 8/1/2018. Certain files relating to case has been found missing, and on which the FIR was lodged. The criminal case was instituted against the Lekpal, and later on by this court proceeding has been stayed. Lekpal Thakur Prasad thereafter died, and the criminal case was abated. Now, related to his mutated land, the land which is mutated from the petitioner. According to the report, the sub-divisional magistrate Nizamabad, the petitioner is in possession of half of the portion of the land in question, Gata number 87, area 01860 hectare, which is 415 kadi, out of which area 207 kadi since the very beginning. It is clearly mentioned that the possession of such land which is in dispute was always in the possession of the petitioner. Although the state government had lodged FIR against his cousin and his aunt, but the petitioner has not made any effort to lodge FIR or complaint against his cousin, who were responsible for initiating proceeding for mutation of revenue records in the names through their mother. Hence, it cannot be said that harm has been caused to the petitioner. If any harm had been caused to the due to wrong revenue entry, it is because of the cousins of the petitioner, namely Patiram, Baburam, sons of the late Ramdhari. The petitioner neither initiated criminal proceeding against them nor filed any suit before the revenue court for cancellation of such entry made in the revenue record. If a mutation entry has been made under section 34 of the UP Land Revenue Act on the basis of such misrepresentation, the proper remedy for the petitioner was to file an appeal against such a mutation entry, and in case he did not get relief, he has remedy could have approached to the Board of Revenue in revision. And last point is, the petitioner could also have the remedy to get the land back by filing a case under section 229B of the UP Zalar Act for declaration of his Bhumi right against his cousins and his aunt. He did not take recourse of any of the remedies that was legally available to him, but he became furious and fight Lok Sabha elections, kidnapped his uncles, his cousins for the such mistreatment against him. Argument against the mental agony. The mental agony has not been faced by the petitioner. The petitioner was enjoying completely and perfect identity as a living person in village Amilu since the childhood and was remained mentioned in the Khasra Khatuni family register and voter list etc. of the village Amilu. His marriage was performed in the said village. If he has been suffering such mental agony or shame in his village for being called as a booth, but instead of this, how can his marriage has been done? His marriage has also been performed in the village, and no such evidence in any record maintained by the relevant department that said he was called as a booth. When the fact came to the knowledge of the authorities on a complaint being made by the petitioner, the chief revenue officer of the inquiry, in pursuance thereof, the district magistrate had passed the order aforesaid in 1994, recording his name in the recording name of the petitioner in Khatuni. The petitioner did not suffer any mental torture, physical torture, or financial loss, as the petitioner continued to live in village Amilo and got married, bought and sold land, and had begotten children. One of his children is running a gas agency. And based on the fact stated above, it can be concluded that a mountain of a molehill has been made by the petitioner only to claim compensation from the state government for a wrong which was initially caused due to the greed on the part of the relatives. The petitioner has not filed any FIR against his relatives, and he has also not arraigned them in parties. In this case also, no such declaration of death of the petitioner was made by the state government. It was his relatives who had initiated the proceeding for the mutation against him under the section 34 of the UP Land Revenue Code Act. My prayer for the court is that the defendant humbly prays that this honorable court may dismiss the writ petition for the compensation of 25 crores and pass other order or direction as may be deemed to fit and proper in the interest of justice and equity. Yes, sir.
My lord, for Karur defense, they are talking about dismiss the writ petition of my client Sri Lal Bihari because they have no any subsequent evidence to dismiss the writ of my client. They are talking about an oil factory running by my client. We all know that when the person was there in the eye of law, so no work was done by the state of law and the dead person in the eye of law. And second, once they are talking about the marriage of my client Sri Lal Bihari. The Lal Bihari was the school teacher. So, a school teacher in the village of Alampur, and he is frequently dead by the cousin brothers. So the marriage point is held that he is the age of 18 when he is not conducted the dead person in the eye of law. So this is the no any other point raises on behalf of marriage, sorry sir. And they are talking about another point, Lekfal. So Lekfal is duty bounded to do his work in the eye of law and not violate the right was doing in the eye of law. And second, once they are talking about meal of a day, my client was suffering from meal of the day. He is not taking any subsequent right in the land that accused by the cousins of the defense. And the another point they are talking about the case file. In the behalf of case file, I am already talking about my client doing every effort to sue case and to maintain in the eye of law. I am talking about the points. First point, applied for a widow pension, but no one heard his person. And third point, protested in Uttar Pradesh Assembly, but no one heard. And first point, I am talking about register a false case with police for our writing. So why police did not take action against him? And after that, I am talking about the right of my petitioners was violated. Generally, in the Article 21, the right of life of person, including the right to live with her dignity. But in this case, my client was not living in a free right of life and not living in a dignityful life. According to this, I have a case law, first Maneka Gandhi versus Union of India, 1978. The landmark case guarded the interpretation of Article 21, right to life and personal liberty of the Indian Constitution. Any arbitrary action by the government, including wrongful death, my lord, including wrongful death, in this case, the wrongful death shown by the prosecutor defense was brought within the ambit of the interpretation of Article 21. And the second right of my client was right to property. The right to property, it is a constitutional right of every person living in India. Article 300A, the right to property is a legal right to use and dispose of one's possession. My lord, point to be noted, the right to property is the legal right to use and dispose of one's possession. And the European Charter of Human Rights stated that everyone has the right to property. But in this case, the defense has declared dead and refuses the property of my client, Lal Bihari. In this right to property, I have some case laws. The first case was Vidya Devi versus State of Himachal Pradesh 2020. In this case, court held that state as a welfare entity governed by the rule of law could not arrogate powers beyond those permitted by the Constitution, sir. And also state cannot. So I am talking about, in this case, they are talking about state. But in this case, state already invoked because the lakefall, it is a duty bonded and it is a officer of state. And also stated cannot take away a person's property without paying adequate compensation. My lord, they are talking about adequate compensation. In this case, the person has not enjoyed the right of property. So, in this case, Vidya Devi versus State of Himachal, they are talking about adequate compensation. And after that, the third right of my client was human right. Beyond the specific constitutional right, the actions against Lal Bihari violate basic human right. The principles of basic human rights was dignity for life, respect and fairness. But in this case, my client Lal Bihari was not living free dignity for life and not living respectful life, or the fairness of law was not heard by police and anywhere. And the Universal Declaration of Human Rights, UDHR, provide a framework for fundamental human rights, and in this case, it clearly falls short of those standards because UDHR already talk about everyone's right to live a dignityful life, respectful life, and fairness in every citizen. And other point, the fourth right of my client or every person, a right to equality. Article 14 Indian Constitution, it is stated that according to Article 14, it is the right the state shall not deny any person's equality before the law. My lord, in this case, the state denies all the equality of my client to sue case or enjoy his life or dignityful life. But in this case, the law, equal protection of the laws. In this case, he was treated unfairly and unequally compared to other citizens. My lord, please note down that point. He is unequally compared to other citizens because he is dead person in the eye of law. So how the citizens compared same due to the fraudulent actions and systematic corruption. My lord, it is a pure systematic corruption because in this case, a Lakefall already involved. He is also a state officer. The system was manipulated to target Lal Bihari unfairly. According to right of equality, I have a case, United Air Travel Services versus Union of India. The Supreme Court held that it was a clear case of violation of Article 14, my lord, a right to equality, and court granted 5 lakhs as a compensation. And on the next behalf, I am talking about compensation on behalf of the writ petition. In this case, my client petition filed on the behalf of compensation. So I have some information regarding the writ petition. The Punjab and Haryana High Court has made it clear that a writ court may award compensation to a person aggrieved in addition to the independent right. Sir, it is an independent right of a person to party to claim compensation under the private law in a civil action based on tort. It is a main form of tort to action and compensate my client. Regarding the compensation, I have a case law, Neelavati Behra versus State of Orissa. The judgment of Supreme Court held that the relief of monetary compensation as explanatory damages in proceeding under Article 32 by Supreme Court and Article 226 by High Court. In this case, both the courts are liable to compensate the person who is coming through the writ petition. Establish infringement of individual rights granted under Article 21. Article 21 told that he is led to dignity for life and right to life. So this was violated in this case of my client. So constitution is a remedy available in public law and is based on strict liability for contravention of the guaranteed basic and indefinite rights of citizen. I had another case regarding the compensation on behalf of writ petition. The second case was Rohtas Kumar versus State of Haryana. My lord, in this case, Supreme Court has granted compensation for violation of Articles 14 and 21 causing death of petitioners. My lord, in this case, this was the main point. Article 14 violates, Article 21 violates, Article 300A violates, and my person causing death. It is a illegal, it is a frequent death. As in a fake police encounter. Just a second, sir. I am talking again. The Supreme Court has granted compensation for violation of Article 14 and 21 causing death of the petitioner's son in a fake police encounter. The court has directed to state to Haryana to pay 20 lakhs as a compensation, sir. And on the basis of lastly, because some Lakefall is a state officer involved in the case, so I have some penal provisions regarding this case. It is a complete criminal conspiracy case, sir. In the section 61 of BNS 2023, all of them together have committed the crime of criminal conspiracy. In this case, the Lakefall and the cousins of my client doing similarly the conspiracy, which is punishable offense. They got my client death certificate made by colluding with the revenue officials and then took away his land, and my client had to wander around. So I expect to the Honorable Court that they are punishable under section 61 of BNS because it is a criminal conspiracy case. And the second penal provision is cheating for cheating under section 318 subsection 4 under the BNS. They all are committed a serious crime with my client by frequently usurping his property. I expect to the court to consider this as well. That's it, my lord.
May I proceed with my argument? Regarding his mentioning about the Indian Oil Gas Agency, Indian Oil Corporation's gas agency, which his son, petitioner's son, was running. and he is a school teacher also. So it cannot be said that he has no right to livelihood, or he had no means to continue his livelihood, or he has been fighting for even 1 meal or 2 meals a day.
Objection, my lord. It is a personal right of client to enjoy his life. The son and wife are other person. They are already takes the other family, but the client who is dead is the similar person.
But the gas agency was running by his son, the petitioner's son, and Lal Bihari is a school teacher, and he has also bought the land in 1988. On the page number 2, para number 2, we can see that the petitioner had purchased the land from Ashraf Ahmad, Jaya Alam and Sabbir Alam in 1988. But the petitioner had got his identity in 1970s, in 1994. So how can he bought a land of such area 0.812 hectare when he is suffering for 1 or 2 meals a day? So it can completely contradict his claims, and suffering on a meals a day. Later on, violation was decided by the NHRC. The violation, he is claiming that he right according to Article 21, he has right to life and right to live with dignity life. But the NHRC has the matter was referred to NHRC, National Human Rights Commission, who decide on such matters, serious matters. And he has decided to proper remedy and direction the state officials to take appropriate actions against all the erring officials. But here, the
Human Rights Authority already talk about dignity for life, respect for life, fairness life. So how they are talking about that point?
But NHRC did not directed any compensation for it, for such. But it can also be mentioned that the right to life, right to such property and for declaration of he is not dead was given to him on 1994. But he has came with such claim for the compensation later after 11 years after such correction. So this completely suggests that there is a mentality to get some extra more compensation from the state government. Also, he has
objection, my lord. My client doing all the facts for regarding he is able to live in the society. What all the facts was denying by police officer and he is doing in the assembly, but no one focused him. It is a main point, sir.
But the court already suo motu has considered his writ petition and tried the case on whose decision he has got such a entry mutated in the revenue record in 1994. And in between, when such a matter is completely in media and all, where Times Magazine also published some articles about it, and which grabbed some attention to the media and filmmakers, and he has get the film, and a film was also made on behalf of such.
But the film was held after he is alive by court, and the UN was registered in his charter after he is registered alive, because before 18 years he is dead. It is a point, sir. Note down.
It is completely right that he is dead, but he has other sources to get remedy. On page number, I want to refer the court to the page number 6 and 7, in which it is clearly mentioned that if the mutation entry has been made under section 34 of the UP Land Revenue Act on the basis of misrepresentation by his cousin and his petitioner, the proper remedy for the petitioner was to file an appeal against such mutation entry. And in case he did not get relief from such authorities, he could have approached to the Board of Revenue in revision. But he has not done anything. But instead of this, he protested in the Lok Sabha and contested for the Lok Sabha elections, kidnapped his own cousin.
My lord, how my client fired?
Kidnapped his own cousin. Let me conclude my point. And he kidnapped his own cousins for such popularity, and also bribed the officials of the police station. to write his name in the fake FIR, but he has returned the bribery. He has also mentioned that. When claiming that why police officer did not take the bribery, it is a question of law which can be decided by the criminal proceeding against such officers. And regarding such Article 14 violation, he has all right to equality. He has remedy to proceed with such remedies as mentioned in there. So by filing a case against him, and the petitioner could have filed the case under section 229B of the UP Zalar Act for the declaration of his Bhumi right against his cousin and
perfect violation of right of equality.
He has all right to fight for his rights, but he has not concluded it. That's it.
They are talking about right to equality and about the FIR of the revenue officers, because the revenue officers already concluded in the offense or doing misjudged with his cousin, with the defense cousin's brothers, and they are not registered any revenue FIR maybe. So this is perfectly irregular point, and they are talking about the next point. It is the right to equality. In the Article 14, it is stated that the right to equality shall not deny any persons before the law. It is equal protection of the law, sir. So how they deny this right to equality article? In the case they are already talking about Article 14 violation, the court granted 5 lakhs compensation. And after? Okay, sir.
As my colleague is saying that Article 14 is violated, but how can Article 14 is violated? He has all right to violate it. All right to file such case against the accusers who caused his misrepresentation or mutation against him. But he could have all the remedy. There is no one-sided basis which can be said that the petitioner did not get any of the such rights. He has not clearly mentioned that which of the rights in the right to equality, what right have been of his right have been obstructed.
My lord, it is a systematic fault to concede my client dead for a long 18 years period. He is suffering from many more injury, many more unfair in the society and unequally compared by other citizens. So it is the right of equality violated. The clear provisions of.
So regarding to his point, he has suffered 18 years of declared debt. We agree that he has been declared dead, but it was not because of the state government, but it was because of the petitioner's cousins and his aunt, who has bribed the officials and declare him dead, and this causes all such proceeding against the court. And court had already wasted too much time regarding this case, and there is no point to continuing with such arguments or such for compensation which is malified, is clearly shown in his statements.
So it is not only the cousin brothers concluded, but also the Lekpal also concluded him. He is a state officer. So how he is doing that type of illegal work to making my client dead? That's it, my lord.
The concerned Lekpal also has been punished, and criminal case was instituted against the Lekpal regarding his queries, and Allahabad High Court stayed the proceeding for some reasons, and later the Lekpal thereafter died and criminal case abated.
It is the note of my client. They are talking about the criminal case was heard for the Thakur Prasad, who is the Lekpal. It is not that my client's fault. The Lekpal doing that crime doing the crime with cousin brothers to establish my prosecution there. That's it, sir. And lastly, sir, I am again talking about it is a fully established case by my side. The petition has been filed under a prayer. I issue the writ order in the action of nature. Amendment commanding the will. So it is my request to court to pay compensation of Rs 25 crore to the petitioner for his business loss and the mental agony. Thank you, sir.